Hello, everyone. Welcome to our lecture today with Mr. Clark Lackert. I want to first thank Clark for coming all the way out here to speak to us today. You know, it's very exciting to have him. Clark is an international expert in intellectual property issues, especially as they relate to intellectual property in space. He's written in several publications, including the American Bar Association. So without further ado, let's welcome Mr. Clark Lackert.
Okay, thank you very much, James. It's really a pleasure to be here. I think that this topic, when you think about a few years ago, people would be sort of looking at you like, when you're talking about space, what does that mean? But now it's a very hot topic. And in fact, I was just talking briefly before that a number of major law firms now are hiring in the space law issue. You know, all these different issues are coming up. They need departments now. So I'm looking forward to talking about these. Please think about it for yourself. One of the things I'm going to tell you is just don't hear a lecture and that's it. I want you to think about one question. How would you protect IP in space? What would you do? And I think everyone has a different idea, and of course they're really valuable. Next slide, please. Can you get it, or I can get it if you want? Let me see. All right, so I can do it. So what is IP? We'll talk about that. How do we create IP rights? I mean, you've heard of IP, but what is it? What are the current treaties in outer space? Now, the question will be, again, I want you to think about, are these treaties really a legal system, or are they simply telling us certain general principles which cannot be enforced? What can be done to remedy it? And of course, what would the future look like? Well, IP is intangible property. So let's think about this for a minute. When these treaties protect property, they're talking about satellites, spacecraft, and so forth. They're not talking about intangible property, which is ownership and inventions. That's patents, commercial symbols, trademarks, works of art and authorship. That's copyright. Business secrets, also called trade secrets, and original creations. And physical space, physical property would be, say, spacecraft, satellites. There are now almost 10 to 20,000 satellites over Earth. And if that's a major satellite, for tiny, smaller satellites, there could be hundreds of thousands of satellites orbiting. We'll talk about that in a minute. So the life cycle of IP is to create the intellectual property, then to maintain it, keep it alive, and then finally to enforce it. So again, very simply, patents would be connected to inventions, trademarks would be connected to commercial symbols, copyrights for art and authorship, and trade secrets for business secrets. Here's some sample trademarks. I just want to show you what it looks like. This is a simple slide, but you get the idea that what happens when all of these trademarks start entering space? Who's going to protect them? A few years ago, you might have heard that there was a Red Bull platform in orbit and someone jumped off the Red Bull platform. You might have heard about that. The first thing I thought of was, well, how do you protect Red Bull? It's in space, right? So what happens, these trademarks and others are already in space. There's a new orbiting platform that's making pharmaceuticals in space. There are other major companies that are beginning to operate in space. I'm only focusing on trademarks because I can't look at everything in patents and copyrights. This is just one example. It's a little bit simpler example, so we can take a look at it. And how do we make a trademark? Well, basically, there are two ways. We use it or we register it. So, right again, think about it. How would you do that in space? You could probably use it in space, but you're probably not going to register it in space, at least not yet. And we have to maintain these rights through registration renewal and for the use. So again, think about as we talk about the subject, how would we go about registering trademarks in space? So where do our current 8 billion people live? Well, you can see India and China are about the same, and other smaller countries, you know, are on the other side, but we have Indonesia, Pakistan, and so forth. All of these countries are currently in any global trademark portfolio. Most of us protect portfolios of at least 150 to 200,000 countries. In my own company, the World Trade Centers Association, we have a similar amount. And I just want to give a disclaimer, I'm speaking on my own behalf and not on behalf of my company or anyone in my company. So these are my own personal views. And how do we enforce the trademark? Well, the magic words are likelihood of confusion. That is, we're going to create a trademark which will protect the services or goods, but we will stop anyone else from infringing through likelihood of confusion. And if we don't enforce our trademarks, we're going to lose the trademark. So it's use or lose. We'll think of it that way. And how does that operate in space? How would we, even if we registered a trademark in space, how would we protect it? And how would we use it, right? Here's just, I couldn't resist. I mean, we can see if we can tell the difference between fake and real counterfeits. Here's one of the first things I want to tell you is, right now, space is lawless. There really isn't a system there, and we will have counterfeiting in space. There's absolutely no question in my mind that this is coming because there's no regulations per se in space, and we'll look at those in a minute. But think about setting up an orbiting lab. We have labs now in orbit making counterfeits, counterfeit pharmaceuticals, counterfeit products. I'm not sure if they're going to make handbags, but they will make software, counterfeit all kinds of products will be made in space if we don't hurry up and have the law catch up with technology. As we can see, one of the themes I'll be talking about is originally space was looked at as exploration, looking at new planets and the moon when we first got into orbit, then we went to the moon. But now we're talking about commercialization, and that's a key point for you. We're commercial, of course, we still have exploration, but we're commercializing space, which is where we come in. So this is your question that you'll be dreaming about tonight. Does outer space have a legal system? I think, I might be wrong, most of us assume it does. Oh, yeah, well, of course. I mean, we have people, right now, let's see, Rolls-Royce is putting a nuclear reactor on the moon. India has landed, as you know, on the South Pole. We have asteroid mining. You just saw a NASA spacecraft land in Utah. They went to an asteroid, picked out some rare minerals and brought them back to Earth. Does this operate outside of a legal system? Is that what we're talking about? And I think, again, think about it. If this can, and I was mentioning it before, a few years ago, you might remember one of the Starlink satellites almost crashed into a European Space Agency satellite because no one kept track of the orbit. So they were getting close. Luckily, the ESA, the European Space Agency, diverted the trajectory. I just mentioned this. This is a plan that Rolls-Royce is making for the moon. This reactor supposedly will be used for peaceful purposes to help the colonists, which will be arriving within the next, say, 10 years. So this will be providing power for the various moon bases. On the left, of course, is the Indian spacecraft that just landed, and on the right is the new Varda lab. Varda is making now pharmaceuticals in space because they want zero gravity. It's apart from the rare minerals found in asteroids, zero gravity is very good for also making optical glass and a lot of other types of products, which will be very well done in space. So why should we care? Well, what is outer space? Let's remember this. Outer space is 100 kilometers above Earth. Let's keep that in mind. It's called by the way, there's a huge thunderstorm going on, so hopefully we'll keep our power. Maybe that was Dr. Carmen coming back. I don't know. That's his line. It's called the Carmen line. The Carmen line means above the Earth's surface, 66 miles, 100 kilometers is a definite definition of space. There are others, but that's what we work with. And now we're looking at, as I said, we're going from exploration to commercialization. We had first strict government control over space flight. Now we moved into partnerships between private entities and the government, and eventually, and we are moving closely now to total private spacecraft, total private use in space. And Citigroup has said that by 2040, we will have 1 trillion with a T in the space economy, 1 trillion volume, and they will have what was called, very important for us, we'll talk about this later, circular space economy. And what does that mean? Many of the treaties we'll look at talk about which launching country we're talking about. Is this coming up from US or Korea and so forth? The circular space economy, which is coming, will have no connection with Earth at all. It's going to be a flight from the moon to the space station, or from from different orbiting platforms to Mars, whatever. It doesn't matter what's on Earth anymore. This is going to be an independent economy which will be existing. And we should learn let's learn a couple of terms. LEO is called low Earth orbit, and HEO is high Earth orbit, and of course cislunar is between us and the moon. That's another term for us. Also, why should we care? We have to stay ahead of this development. I mean, I don't know about anyone here, but I was shocked how quickly this is progressing. And apart from, we talked about space tourists, yes, that's important, but mining asteroids and making space stations, a hotel is supposed to be going up in 2027. That's only 3 years from now. Now, maybe it will be delayed, it'll be 2030, but still, that's very, very close. Who's going to control the space station, the hotel? What about the people traveling to the space station? Where is the labor law? Where is the criminal law? Where is the food and drug law? All these things for people living and working on the station. And of course, from my perspective, intellectual property law. So my point to us on this issue is that it is very urgent that we look at this. We can't just say, oh yeah, well, I just assume there's protection. No, there really isn't any protection, and we'll talk about that. So we have certain national laws, and we always look at this law. This is called the U.S. Patents and Space Law, 35 U.S.C. 105, which says that any activity on a spacecraft launched from the United States is subject to the U.S. patent law. So that's one of the few rare exceptions in the world where we're actually saying that if you make something on a spacecraft, you will be under our U.S. law. And we'll see here there are a number of UN treaties. There's the Moon Treaty, Rescue Agreement. So we'll go over these. But essentially, they're looking at the general exploration of space. And unfortunately, intellectual property is not mentioned at all. And in fact, even some of the newer treaties don't even talk about IP. The ISS Treaty, the International Space Station Treaty, it's also called the Multilateral Agreement, is, again, interesting because it's made up of different sections called elements, and each element has its own law. So the US element has US law and so forth. That's an interesting approach. As I've said earlier, we've looked at the exploration of the world outside, then went to the moon and to Mars, but we haven't really talked about what happens when all these people start arriving. We're going to have, we're moving off the planet, whether we like it or not. This will be one of the first generations where we will have people working and living off of our planet. So how do we protect it? We talked, of course, we have the Global Village, Marshall McLuhan, national treaties. There are a lot of treaties we'll talk about, but unfortunately, these don't happen to affect intellectual property. And we've been in space for 1957, 66 years later, we still haven't done anything. So we've looked at this already about what is happening. The first, remember, Sputnik went up many years ago, and now we're talking about hotels, flights, and of course, the new global and then the circular economy. Now, these are the main treaties. So when we talk about outer space law, these are the treaties you're always going to have to come back to. So from a legal perspective, this is what we have to focus on. One is the Outer Space Treaty, which is the most important treaty. That's 1967. It's the Rescue Agreement, which talks about rescue of astronauts. The Liability Convention, talking about possible liability for spacecraft. The Registration Convention, talking about registration of satellites. The ISS Treaty. The this is a mouthful for us, UN COPIUS, which is the United Nations Committee on the Peaceful Uses of Outer Space guidelines in 2019. These were, by the way, only a few years ago, and they never mention IP at all. They have one, I think, passing reference. And of course, very popular nowadays is the Artemis Accords from NASA. And what does that mean? So the Outer Space Treaty, let's start with that. That is the first major treaty that dealt with outer space. It talks about the principles of preserving outer space meaning not just the space itself, but the moon. They call them celestial bodies, but the moon and the Mars and everything else. It talks about making for common humanity and for the general the good. But it's really more aspirational than enforceable. It's more of a statement of principles. And as we'll see, it's hard to say that with all these new flights going up and setting up zones of influence on the moon and elsewhere, that there's not some kind of sovereignty involved, some kind of some sort of amount of government intervention of making the moon tiny little microstates or middle protective areas. The rescue agreement, again, very helpful and to rescue astronauts, so that if a flight lands on a different country, they agree to return the astronaut. I think that for our purposes and also the liability convention, damage from spacecraft, again, as you know, we have how many of you heard of space junk? Well, there's lots of space junk, and it's going to be falling very soon. It's coming down faster and faster. And the liability convention, it says if there's a spacecraft from, say, France or Germany, whatever, it falls on something, they're liable. Now, whether that's enforceable is questionable. The ISS, the International Space Station, is going to be deorbited in about 5 years, and it's going to cost $1 billion. So what does deorbit mean? It means supposedly it brings it down safely, because if they don't deorbit it, it's going to break up and it's going to be crashing down on all of us. Big hunks of the space station will be falling through the atmosphere. This is a schematic of what's currently orbiting the Earth, which I think will give you an idea of what we're dealing with. A registration convention. Supposedly there are about 3,000 space objects, 30,000, sorry, that are larger than 10 centimeters. And this is what a lot of these dots that you're seeing are actually much larger space craft or other types of monitors, usually satellites. The Moon Agreement of '79 would sound to be a very important agreement, but actually very few countries have signed the Moon Agreement, and it's really not that enforceable again, but again, it needs to be included. So what else do we have besides those UN, the big five, I call them, the big UN treaties? Well, there's the multilateral International Space Station, that's the ISS agreement, which I talked about. The Unicopus guidelines talk about how would we, and this is about 50 pages or so worth, how do we deal with all these issues? Now they're looking at more sustainability, environmental protection, these things, but from our perspective, not much about IP. The Artemis Accords we've talked about. The World Economic Forum has a space sustainability rating system where it's talking about what will and will not be sustainable. And UNOSA is the UN group on the outer space affairs. There is a working group, a lot of people are in that group, about what do we do for creating a legal system and other things for outer space. I mention this because it's always referenced, and of course I would be neglecting to if I didn't talk about it. So people would say, well, it's not the law of the sea. Isn't that what it means? No, it's not really the law of the sea. It's somewhat like it. So the law of the sea, you might have heard, it's basically a flagged vessel issue. If it's not a flagged vessel, then that law of that vessel rules that particular system. But again, whether it's really relevant for us, we'd have to think about that. The equivalent in aircraft is the Montreal Aircraft Convention. Again, when you're on an Air Canada flight, supposedly Canadian law applies, but not always. In the internet, we have the generic top-level domains and the UDRP, which is the Uniform Dispute Resolution Policy. This is a good possible analogy for us, because as you may know with domain names, and I'm a domain name arbitrator now for a long time, this whole system exists in the virtual world. You get a file electronically, and 2 weeks later, you have to submit an opinion. It's done very quickly, very inexpensively. The metaverse, of course, we've been talking about. Again, similar virtual world. Now, we really haven't developed a similar system like the internet, these domain names. And of course, we're all talking about AI now. Whether this is relevant or not for us, it's a challenge. So I put outer space sort of in the same category, but I think we're better off and we're further along with outer space than with AI, for example. Again, I mentioned this earlier, so just remember this, only that we're one of the few countries in the world that specifically protect patents and inventions on a US spacecraft. Now, we looked at the other, when you think about what we just talked about with these different treaties I mentioned, we could say maybe, well, if it was launched by India, maybe Indian law applies, but there's not a concrete legal statement on that effect. There's no specific law. Here we actually have a law saying that it's protected under US law. This, for those who love the Artemis Accords, here's just a quick map. You'll see that Germany was the last country to join, and it's now at 29 countries. There's a lot of press on the Artemis Accords. I would only say it's a kind of a different version of the Outer Space Treaty. So what does the Artemis Accord say? It talks about the moon. Now remember, the moon is 4 days away from us, but the Mars is 8 months away. So obviously it's more likely we'll be going to the moon. I'm not sure if I want to sit in a spacecraft for 8 months. That doesn't sound too much fun for me. And it talks about, again, back to the Outer Space Treaty, just basically to work together, to cooperate, to develop the moon, to share all the scientific data with each other and develop it that way. Of course, when you have commercial companies involved, maybe they're not so happy about the sharing the data, but that's something that they have to work out with the Artemis Accords. And again, I think we're going here. I just want to make sure we get forward here. So here are some proposed solutions, and we'll be talking. Do you have to back to the slides or no? Your control, right? All right, so I'll go over this. So what are the solutions that we talked about? We have a lot of different treaties examined in many articles on this subject. You'll read them online, but they don't have any specific concrete examples of how to solve the problem. We know what the problems are. We have a lack of sovereignty in space. We don't have jurisdictions set out clearly enough. We don't have the will, I think, at the political level to look at this. I mean, again, I was very concerned and surprised that really no one's really even talking about this issue, and it is coming very soon for all of us. So we'll have to think about it. So what would be possible solutions to this? Well, I was the co-chair of the INTA IP and Space Task Force, and we came up with some solutions which we can look at. But again, I think that it would need a lot of people in this room and watching to get involved in this. So what is the first one that we looked at? Well, WIPO, which is the World Intellectual Property Organization, has an international trademark treaty called the Madrid System or the Madrid Treaty. And the Madrid Treaty basically talks about registration of a trademark in the home country and then extended to different countries from a list. One of our proposals we came up with is, why don't we take not so much all of outer space, which is, it's a lot, but why don't we take little segments of outer space? It could be like a segment of the orbit, segment of the moon, whatever you want to come up with, and make it a little jurisdiction in itself. Make it something that we could fit into this international trademark system. Now, why is that important? Because we already have the treaties in place. A lot of countries already belong to this. We don't have to reinvent the wheel. So I think that's something we've looked at. Now, there are challenges for this. One of the potentials that we looked at that might be possible was to create what we call outer space intellectual property office, but just a certain orbiting segment that could possibly be done, because there is an exception in this treaty that says if you have an intergovernmental organization, it can join the treaty. So if we could possibly have an intergovernmental organization join the treaty, which would help register trademarks, it's possible. But again, this needs to be studied by WIPO. I think that it's one way we could quickly get this type of protection we've been talking about. However, whether all countries would agree to this is a different story. However, it is a well-known and well-accepted treaty that does actually have an implementation process, that this actually happens. It's not just a statement of principles. You know, we all need to get together and save the moon, and it has actual certain remedies. The second one we looked at was similar to what we saw with the US Patent and Space Act, which is to extend our national IP laws to space. Why not? This is a question I always ask. Why not take, it seems like it's a pretty simple procedure, I would think, but it depends on the country. Just take, say, our local laws, like what happened in the US, and say we have like a paragraph. These rights extend to outer space, or whatever we want to call space, orbit, moon, whatever it is. At least you have something in writing, something that can be held on to, because what's going to happen is these rights in outer space are going to be extremely valuable. This is billions, and some people have estimated trillions of dollars worth of IP rights. For example, what happens when we go to an asteroid and we get rare earth minerals so we can make products for our computers and our chips and so forth? What happens if we actually own rights in that asteroid? Right now, it's come one, come all. First come, first serve. Does it seem odd to you as lawyers that whoever's first to the asteroid can take everything they want and we go on to the next asteroid? I mean, maybe, maybe not. But if we look back at the Outer Space Treaty, which says it's all for common humanity, how does that act when we're running to asteroids and bringing them back to the US or whatever country you want to talk about? So if there is now in international legal terms, when you have space objects and personnel which are launched, this is called a quasi-territory. That's the official name. A quasi-territory is not, technically a territory, but it functions as a territory. And there, for example, there would be the ship at sea. That's really a quasi-territory. So there you have the ship, what law, and that's why it's very important, as you might know, what the flag of the ship is. Is it Panama? Is it, whatever. So the quasi-territory theory is a way we can get around this. But again, we have to do it country by country. The first suggestion we made was that's a general treaty amendment, which would apply to everyone. The second one, you're going to have to go country by country. Now, it might surprise you to know we had a multinational group serving on the IP and space project team for INTA. And some of the biggest developments are coming from countries you might not think of. Nigeria, for example, is very active in this area. And other developing countries or other countries that need to have more investment or seeking investment, they've made the connection, which surprisingly no one else has made, that if we make our country a very pro-space commerce country, we'll be able to attract people to launch from our country, because those flights are going to be subject to our law. And if we have a good law, then that will be very beneficial to our home commerce. So again, a little bit convoluted, but the point simply is it's apart from all the other complexities, it's fairly simple to just amend our national law. It might not sound that's that easy, but we only need a few lines. By the way, the Patents and Space Act is like a paragraph, yet it has massive, massive impact. So anybody can say, and then another countries that are thinking about, Europe certainly is thinking about this approach. In Asia now has a couple of major powers. Of course, the most important in space are China and India. So they're looking at it seriously. India had a different approach. It's interesting that they were willing to do that, but this is why you need to read the fine print. If we launch it on our spacecraft, the government was saying, we own the IP. Well, that doesn't help us, right? Because that country wants that. So, but that amendment, I think, is now not going anywhere. But the point is, you're going to use our spacecraft, government, we're going to own it. So we'll see what happens now with the private launches on SpaceX and others to see what happens there. So anyway, those are the two first ones we can look at. Now, one that's kind of ignored, I think, and we're saying 2030 because this is something that's realistic. And then we'll get to the far-fetched stuff in a minute. It's, why not put this in your contracts? I don't understand why people can't put the territory of our franchise or our legitimate license for your rights is Canada and low Earth orbit, or space station number 3. I was talking to some people from a hotel chain, and they said, you know how long their licenses last? 150 years. So you're going to be in space in 2300. I mean, come on. So they're not really looking at space per se, but they have such long-term contracts because of various reasons that this makes a lot of sense, because you're going to be able to look to the future. And it gives you a function where you can use these rights to create value. You know, many banks, which you might be studying here, many banks are very looking at your schedule of IP assets, and they want to see what exactly do you own if you want this kind of funding for your private, you know, whatever, your venture capital, whatever. If you say, oh, I own these rights in the US and Japan, and I also own these rights in low Earth orbit, right by where the space station is, and new ones are going up, or the hotels and so forth. So this adds immediate value to the balance sheet. Now, you'll say, well, what kind of value is that? Because just because you said in your contract that it's part of it licensed. The point is, you're looking to the future, because as we've seen in the progress, you know, in the last few, if you look back at, say, 2000, 2010, 2020, if you look at what's coming out of WIPO in Switzerland or the UN, these different committees, you'll find that their language has changed completely. In 2000, 2010, everyone's talking about exploration. Now in 2020, they're starting to talk about colonization or habitation, whatever words you want to use. And they're talking about private rights. And when they talk about private rights, we're talking not just about owning a little lunar home, if you will, but also your IP rights. And I'm sure for those in the group here that are studying IP, in many companies, IP is 80 to 90% of the value of the whole company. What are your patents? What are your trademarks? What are your copyrights? What software do you have? All this, your know-how, your show-how, your trade secrets. And if you can bring that into space and then commoditize it, you have created a lot of value for your clients, for your companies. So I would not overlook contracts, and many people are taking this seriously now. They're already putting it into their agreements. So when they talk about the territory, the protection, where it's extended to, they will look at the schedules. Usually it's on a schedule. They'll see that part of it is in moon, outer space, whatever it is. Now, the next one is also interesting. So this is something, again, we're using this as the near-term things we can do. And remember, we're talking here about practical solutions. We've seen at the beginning that we really don't have, I don't care what you read in online or whatever, there really isn't an international legal system for space. We have treaties which we all say, yes, we're all going to be good, we're all going to treat the moon nicely, and all the, it's not enforceable, really. I mean, we can argue whether it's enforceable or not, but the database is another example. This is a proposal which got a lot of traction in the corporate world, is that in some areas of IP, you can give what's called a cautionary notice. And what does that mean? It means that you tell people, I'm claiming rights in this whatever it is, trademark, copyright, whatever, and whether or not you have it registered or whatever, this is your line in the sand, keep off the grass, whatever you want to call it. I own Hilton for hotels in space. What if I said that? Well, do I have a registration in space? Do I have use in space? Do I have any? The answer is probably not now, or not yet. Even though Hilton was featured in 2001: A Space Odyssey, if you remember that part there, and also with Howard Johnson, by the way, on the spacecraft, on the orbiting spacecraft. So, and Pan Am, I forgot Pan American, right? The shuttle was Pan American. So, what happens? This is simply saying, if you take this to heart, if you try to use this in space, you're going to have to answer to us. Now, what does that mean? Do you have you have a space court? Do you have something that you're orbiting planet? No, but it means you're going to get sued in U.S. court, in German court, or whatever. We don't like you orbiting a hotel with our trademark on it, even though it's an Earth trademark. So this was a similar system used years ago, and I'll just briefly mention it. For many years in the TRIPS agreement, the World Trade Organization TRIPS agreement, which you may be familiar with, there was an issue about how do we protect geographical indications. And there was a very, we can go on what a GI is, but basically they're names of products that come from certain countries. And what happens is they'll say, how do we protect the GI? How do we do it in our country? And it was a total roadblock, a total gridlock. So there was a proposal that we're going to make a database for each country of what we protect in our country. So I'm going to say France, we protect Champagne as a GI. It's not from California, it's from the Champagne region of France. So now again, this is voluntary. This is on the GI side. We're just telling you, we claim these rights. You claim your rights for your country. Everyone claims their rights. And we're going to make a major database. We're going to have everything together. Our suggestion here is to have a similar system for space until we can get all the other mechanics in place. The registrations, the courts, the enforcements, the arbitral tribunals, all these things. We're going to have the system where we just do something right now, because right now we're in total void. We have nothing right now. It would be great if we could at least make a database or something that we could start protecting IP in space. And by the way, this talk 5 years from now, it will be a totally different talk, because then we're already going to have registrations and everything else. You say, oh, I heard about that in 2023. So that's that proposal. The courts, why not start, and this is interesting for everyone here, start litigating this. Do you protect it in space? What is the US proposal? What is the German proposal? Let's start filing or using our current national courts to talk about what we own and what we don't own. There's no clarity right now about what we really have and what we don't have. So let's talk about, say, a German flight or whatever, Indian flight takes off and everyone denies you have any protection under the Indian law. But let's take that as an example. Well, you file a case in India. Let's see what happens. Let's see what the court says. Let's see what the Supreme Court of India says. So I encourage everyone not to file a lot of lawsuits, but look at IP offices, look at national courts, try to get some kind of, if you will, space common law, if we want to call it that, to, as we have with somewhat like the law of the sea, whatever, we have some form of body of law on that. Let's try to get that for space as well. There is by the way, there is an international space court, which is in Paris. You might be shocked to know, but no one usually uses it much. It really doesn't have much activity. But again, we're talking about IP here. A lot of space litigation is, which you might be working in. I told you at the beginning, a lot of big law firms now are hiring space lawyers. It might be more of registration issues. Or I know a case which is talking about government rights versus private rights, or whether you have a license to take off or not, and all this type of thing. But IP is coming, whether, but again, there are commercial issues, there's financing issues, there's insurance issues. What happens if your flight to the space station has some damage or whatever? So that's all coming, but the IP side is important to include. Now, an obvious choice is arbitration. So arbitration doesn't need jurisdiction. It doesn't need the courts, right? You say in your contract, and by the way, who uses this is the European Space Agency. If you launch on our flights, you're subject to XYZ arbitration and whatever they want, London arbitration, or Paris arbitration court. So, or the WIPO. WIPO has a very active arbitration and mediation center where it handles different kinds of IP disputes. So the arbitration is easy. You put it right in your contracts. Any disputes in this, under this agreement, you agree to submit to binding arbitration in so-and-so arbitral court. We choose the law of Germany, whatever you want, the courts of Germany, and so forth. So that's a way, again, you can do this now. You don't have to wait for these international treaties to take effect. You can add contracts in your contracts, you can put in arbitration, you can set up you can, if you don't have a database, just send out a press release. Why not? Red Bull says, anyone uses Red Bull in space, you're gonna have to answer to us, or whatever. We can do the platform, remember years ago with the parachuters, but anyone else does it, that's it. Now we move ahead towards another 10 years. Again, this is probably a kind of an aggressive schedule, but let's take the big five we talked about at the beginning: the registration, the rescue, outer space treaty, and so forth, and let's expand them to IP. Why not? But will we get a consensus with, as we know, the geopolitical situation now is very difficult to get a consensus. And by the Artemis Accords only have 29 countries because they're considered a NASA US invention. But space treaties plus, let's look at taking current space treaties and adding IP to it. Again, why not? For example, the Registration Convention of '75 talks about registering satellites and spacecraft. So we're theoretically, unlike what I talked about with Starlink, we're supposed to know, theoretically, where all of these satellites are, these tens of thousands of satellites. And there's a vast process of monitoring them, their orbits, and so forth. I think in Starlink they have, I don't know, over 10,000 satellites. So what about saying, we'll register IP also? Why not in our registration system? Why don't we say, I'm going to register my patents, my trademarks, my copyrights, and so forth in this international register, so it gives notice to everyone that I'm claiming rights in that particular creation, whatever creation you want. So this, again, it takes, the problem with treaties in general is if you have a new treaty, or in this case, just what I call space treaties plus, adding something to a treaty, you're going to have a lot of political and diplomatic problems. You're going to get bogged down. That's not to say it's not possible. And I think this is something, that we can all agree on, at least most of us can agree on, that we're protecting intellectual property in space. It doesn't, and then I keep encouraging people that are thinking about this that it doesn't have to be the overarching treaty that solves all the world problems. No, no, no. What we need is a start. We'll call it Space Treaty Light or something that starts the process. That's what we need. We don't have to have the final results, but we need to have, we're never going to get a new outer space treaty. We'll talk about that in a minute, but we'll get the process started. So IP registration convention. Why don't we say, even in the Outer Space Treaty, the original one, as you remember about, it's for common mankind. Well, if common mankind, if we can all agree on a law of some sort to protect IP, that's not violating the treaty. I think we tend to think of the Outer Space Treaty, when you go back, you can read it, and it's not that long, that somehow creates what they call, a common ground and a common ownership of outer space. It's not what it means. It really isn't. There are many commentators that say it doesn't mean that. It means we should all work together to protect space, but that doesn't mean we shouldn't have any laws or we just go wild to do whatever we want. So when you hear about the Outer Space Treaty means everybody gets to enjoy everything, I don't think that's correct. And now we're talking about the safety zones on the moon where landing, and this is now actively discussed, this area, this country has this safety zone and this country has that safety zone. That's where they can make a little habitation and a little landing pad and everything else. What does that mean? Does that mean common humanity? I mean, now we're beginning to carve it up into territories. So I think this is definitely, if we can get some kind, we don't have to have all 200 countries sign this. If we could just get some of the major countries to sign this a very simple amendment of a paragraph or two, that might be a way to deal with our situation. Another possibility is, so these are midterm possibilities, a creation of a new arbitral tribunal, such as the UDRP panel system at WIPO, either virtual or analog, for the settlement of disputes. So right now, for those of you familiar with the domain name system, companies register domains. If there's a dispute, we take it to WIPO. Everything that is in this arbitration is online. It's totally virtual. No one, in fact, we're not allowed to talk to anyone. This one can't talk to that one. I'm an arbitrator. We're not allowed to talk to anybody. We look at what's submitted in writing. It's totally in writing, no arguments, totally just basically two basic documents, a complaint and a response, and you attach all your exhibits, all your evidence, and then you make your decision. So why not do that for space? Why can't we have a virtual arbitration system for space? That way we don't have to worry about jurisdiction, whether we're in Germany or in Japan or wherever. What we would do is say, if I fly into this and use this system, then I agree that, and this is, by the way, I want to emphasize, the WIPO system is all contractual. So we agree, if we use WIPO, that we're going to submit to arbitration from WIPO. So it would be the same for space. We would say, if we're going to use our launch system, we agree that we're going to have this virtual arbitration. We have to set up the UDRP similar to what the factors are, but very frankly, the UDRP is only 4 or 5 pages. And yet there are I think tens and tens of thousands of decisions which have affected major domain names worth millions of dollars, done in 2 weeks, all online. So 2 weeks, the tribunal says, no, you're violating the rights. You have to transfer your domain name. They can go to court, but they can't appeal. It's in the system. You can go to separate court. And then finally, now we're looking way in the future, a new comprehensive IP space treaty. Wouldn't that be wonderful? We'd have IP, trademarks, copyrights, patents, and everyone, and with fully developed acquisition of rights, scope of rights, and enforcement mechanisms. If this is violated on the moon, you go to this court or this tribunal. That seems difficult right now, but you never know. with the changing scenarios around the world, there may be some impetus for at least a study group. That's how things start at WIPO. They have a study group. Just have a study group start to at least look at the issue of creating an outer space treaty volume 2 or whatever. So that's definitely a possibility for us. But again, something to keep in the back of your mind. Another aspect which some people have thought was helpful is, instead of making this comprehensive treaty, you have it breaks up according to space regions. Now, I told you at the very beginning, outer space is above 100 kilometers, but that's a lot of territory. That's interstellar space, that's everything. So we divide it up into this zone of the low Earth orbit, this region of the moon, Mars. They're already planning Mars City for 2050. So it's supposed to have 2 million residents by 2060. 2 million people living on Mars. That's why I always tell people when I talk to them, I said, you could be working and living on Mars. You're going to want to have some system there. So, and that's why students are really important, because you're the ones going to be doing this. You're the ones going to be actually writing these laws for Mars or for the space stations. So there we would say, create a local registry, and that will handle that particular thing. So one space station has its own law. It's a way to deal with it. It kind of cuts it down. So let's wrap this up. We're getting to our hour now. So what are our urgent actions? Well, one is that we start at least thinking about space issues. You know, by the way, everyone start paying attention when we heard the big law firms were hiring space lawyers. Now I get a lot of phone calls. Oh, well, Irish space lawyers are looking at it. Let's look at IP, arbitration, insurance. Look at it. What about insurance policies? What about joint ventures? What about all these other issues? It doesn't have to be even IP oriented. If you're looking at space law, right now there's nothing. Anything is better than nothing, in my humble opinion. And people have said, oh, well, it's so vast and we'll never be able to do anything. I heard the same argument for the internet. If you like a decade or two, we'll never be able to solve the trouble of the domain names because they're everywhere. And well, we have it now. We have a working system. You might be shocked to know that when the photocopier came out, it was the end of copyrights. We heard that also. That was funny. Next is we have to start doing public relations with governments and other big movers and shakers. We have to raise this to these different organizations. They're not going to pay attention if we simply give a lecture about it and they say, oh, well, how does that affect me? I mean, they have to think that they have a stake in the game and that they have to be serious about this. So let's look at what I just talked about earlier. Let's look at extending jurisdiction to space, drafting laws, regulations. And it's important to know, I think, that it's connected to all the other space legislations. You know, you're hearing a lot of people interested in perhaps if a spacecraft takes off and it explodes, or there's some issue with insurance, but what we need is to have something that looks at the general space legislation and also with IP. And I've also said earlier that this type of approach is, again, kind of piggybacking on the other issues. So if you see something in, say, Congress or elsewhere that's talking about space legislation about a totally different unrelated area, let's say, well, can we at least sneak a little IP in there somehow? And I think that the big concern I hear about why people don't want to put IP in space legislation is they're worried that somehow it's going to be hampering space development. That this is somehow going to be, oh, we're going to have a big bureaucracy telling us what we can do. No, we can't mine this asteroid because this committee said we can't do that. But I always argue it enhances space activity. It enhances private investment. So by this time, in 10 years, 20 years, I think that I would be very surprised if within 5 to 10 years, we don't have some kind of activity. But you're on the ground floor here. We're just beginning to start thinking about this. And of course, obviously the technology is becoming to go really far ahead of the law. we'll leave AI to the side on that one, but I mean, it's really going so fast that everybody's trying to catch up. So I mentioned that Indian legislation where they want to own the IP, but my second point here is that, do we want a gold rush? Does everyone at the last minute have to rush into outer space and protect something? Well, we're trying to avoid that. And I think that I always ask this question, why would you want to invest in space if all your ideas, your inventions, everyone are pirated? Why would you want to spend any money manufacturing on a space station or in the moon if everyone can just copy it and you make nothing? So it's a private sector, but remember, IP rights protect both the private interests, but they also protect the public consumer from piracy, from pirated baby food, from everything you can imagine that IP rights are protecting. It's not just, we're going to protect the big trademark or the IP owners, it's really for everyone. So what is my vision of the future as we wrap up? Well, I believe in multilateral, plurilateral, bilateral. We will come together at some point. We didn't mention patents. Of course, there's the Patent Cooperation Treaty, the Berne Convention for copyrights, and Madrid Protocol for trademarks. We talked about the circular economy. None of this launching state stuff with the law of the sea makes sense if no one's launching anything. They're launching it from one space station to the other. It doesn't make sense. Outer space should be a territory for arbitration and for your contracts. It doesn't cost you a cent to put something in a contract. It's protected in Canada and outer space. And we're going to be having cities on Moon and Mars. We need to have some form of administration. And again, it doesn't have to be overly burdensome, but we're moving very quickly from exploration to commercialization. And I think there was a recent study about one of the first flights to Mars, which will be, I think, somewhere in the 2040s. They already 200,000 people have signed up already. Now, whether they're going to make it or not, I don't know. But they're waiting. Unfortunately, it's a one-way trip because there's not enough fuel to get back. But the point is, it's happening, and we have to start somewhere. And I said my final point here for you is, again, look at investment, look at protecting the private-public, but private and public relationship. And we are now in a free-for-all and a legal vacuum, but hopefully we can start moving ahead to start some type of at least minor legislation, what I'll call light, treaty light, something to move us ahead on the issue of intellectual property. Well, thank you very much. And are there any questions? We want to talk about it later, I think. Yes.
One thought I had was, it's the analogy maybe between here and some of these standard setting organizations. They seem to play pretty well together. They kind of end up being international. My understanding is usually that's a group of corporations and companies that kind of agree on certain things, and with the development of SpaceX and Blue Origin and all these commercial entities, that if they were to collectively get together and come up with these kind of standards and maybe get the governments and the politics and all that out of the way, is that something you've looked into?
Well, yeah, I think I think it's a great idea. We're talking, what you're talking about, a little bit different, but definitely related, is the issue of regulations. And we can see that, for example, the International Telecommunications Union, ITU, looks at satellites and so forth, in orbit and whatever. So if we can somehow, even what you're suggesting is even one of those agencies or something change or add to some of the regulations, or which is not the law, like you're changing a new treaty or whatever. I think that might be helpful. Again, we want some baby steps. We want to move slowly into understanding outer space, because right now I don't see people, again, no one seems to be bothered, but I see some people are being bothered now. So I think that's a great idea. Yes. Anything else? Okay, well, thank you very much, everyone. It's been a pleasure talking to you. And I'm sure, and again, if you have any questions or ideas, I would love to hear them, because this is not, as I said at the very beginning, it's not a lecture. I want your opinion, because we're all trying to brainstorm this, how we best can deal with this very serious problem. So thank you very much.
It's